Welcome to our show today. Eric Perrott and I are going to talk about how to take certain enforcement actions in a trademark matter that basically fall short of federal litigation. Most of this is going to be about petitions to cancel and notice of opposition with the United States Patent and Trademark Office, and some of it will be about something called reexamination and expungement, which are two relatively new procedures that the USPTO has begun to offer. So with that, we'll get everything started. Just to give you a background as to who we are and why we're here talking about trademarks. If you've been here before, you probably know that Eric and I are the definition of one-trick ponies. All we do is trademark work. For the most part, do some copyright, I suppose. But trademark work is the majority of our practice. We've been in business for 15 years, and we currently have 8 lawyers located pretty much all over the East Coast and one in Nashville. We have registered over 7,500 trademarks for clients in the United States and also in over 30 countries around the world. The one really cool part about trademark practice is it's international, and a lot of your clients need to work in other countries. So we work a lot to assist with registration enforcement even outside the United States. Our firm does specialize in cases like we're talking about today, where we are looking to resolve trademark disputes without the need for significant litigation. After all, most people do not want to pay lawyers for litigation if they can all help it, and our job is to try to keep people out of court when possible. In addition to the enforcement and defense work we do a ton of, as we mentioned, trademark prosecution work. In that time, we've overcome over 200 refusals with the USPTO that are considered substantive, meaning refusals because of other trademarks that might be conflicting with our clients, and also resolved a couple hundred of the type of matters we'll be talking about today. So that's just a bit of a background with us. Again, if it's not about trademarks, we probably can't help, but if any questions ever come up in your practice about trademarks, we would typically be happy to be a resource. We work with a lot of other law firms just because we can kind of slot in and take care of the trademark questions that may come up. So as I mentioned at the top, today's conversation is going to be focused on initiating various different types of proceedings that can help you protect a client's trademark without actually having to file a federal lawsuit. After all, a federal lawsuit is the most expensive thing you can possibly do when it comes to trademark enforcement. And the vast majority of clients, quite frankly, won't have a budget for it. It's not like a personal injury case in most cases where you'll get substantial damages. Of course, there's cases where you get damages and attorney's fees. Those tend to be rare. Those tend to be hard to predict at the outset. So anything you can do to affect and get your client a result without having to file a federal lawsuit sometimes is super appreciated and can keep costs relatively low. So these are the types of things we'll talk about today as we get into it. And as I always say, please feel free to ask any questions. We've got the chat room open. Lacey and Hunter from our team are going to monitor it and let me know as we get to sort of different waypoints if there's any questions that have come up. Lacey and Hunter, also feel free to obviously interrupt if the question is super timely. I'm more than happy not to drone on and bore everybody. I want to make it as interactive as possible, and we'll go from there. So just as a base, many of you here may already know this, but just in case you don't, we always want to talk about what is a trademark. So trademark, by definition, is something that identifies the source of products or services. So you think about every time you see Nike or you see a swoosh, you know that shoe or that shirt or whatever it is you're buying is made by Nike Inc. And trademarks come in a lot of different things. We commonly see them as business names, logos, or slogans. You may also, color can sometimes be a trademark. Product packaging can be a trademark. Even a sound can be a trademark. My favorite example of a sound that we're all very conditioned to anymore is the Netflix ta-dum, when you sign on to Netflix and you're like, my day is over, I'm about to watch a movie. But that sound, that's trademark, and it's registered as a trademark. So trademarks can be all sorts of things that help your client market and its products and services and let consumers find your clients. I did not change the slide, but here's some examples. You could see, just taking Nike, you've got the business name, different product services, slogans, logos, even what we call trade dress, or in this case, a design of a shoe. Or a design that appears on a shoe could certainly be protected as a trademark. So these are all the different types of things that you can essentially enforce on behalf of your client. So today's presentation assumes that your client has a trademark of some kind that they've either tried to register or have registered, and an enforcement issue has come up. Now, the enforcement issue might be that you have filed a trademark application and received a denial because of another trademark that already exists. It could be that you file a trademark application and another company opposes the application that you filed on some grounds. And we're going to talk about all these types of things as we get into the presentation. The first thing I'm going to cover in the presentation is an opposition proceeding. So an opposition proceeding happens in the Trademark Trial and Appeal Board, which is a tribunal that is under the United States Patent and Trademark Office. So I always say, I call it trademark court, because essentially what you're doing is you're in a court loosely. Some people claim it's not a court, but for the purpose of our call, it's essentially a court. And this court can decide one thing and one thing only. It can decide whether a particular trademark can be registered or not. So if you have filed a trademark application and somebody files a notice of opposition, the only thing that's being decided is whether the application you filed can continue on to registration. Or if somebody else has filed a trademark and your client's worried about it, and you file an opposition against that trademark application, then the only thing that's going to be decided is whether or not that potentially conflicting trademark can be registered. The most important takeaway here is that the Trademark Trial and Appeal Board, through an opposition proceeding, cannot decide whether or not somebody can use the trademark. So even if you get a judgment, you may not necessarily stop the other person from using the trademark, or they may not necessarily be able to stop you. Now, there's another thing we're not going to talk about right now, where you can take a judgment and try to have it applied in federal court. And there's certain limited circumstances in which an outcome in an opposition proceeding can be enforced then in a federal court to stop the use of a trademark. But there's a lot of, there's some really nuanced things there. And so what we typically focus on with our clients is, if we're going to file an opposition, or you have an opposition filed against you, just remember, you're not going to be able to get any attorney's fees, you're not going to be able to get any damages, and you're not going to get a judgment that says they cannot use the mark at this stage. The only thing you're going to do is block the registration. Now, that can be very valuable in and of itself, but it's really important to understand that particular limitation. Now, an opposition proceeding has to be filed within a very specific window of time. When you file a trademark application, once the government reviews the application, there's a 30-day window in which somebody can file this notice of opposition. So typically what happens is, let's say we're on the plaintiff side. Our client has a mark that's registered, and what we have going on is something called a monitoring program. So there's a bunch of good software out there these days that will alert you if a trademark that is similar to something that your client owns is filed with the USPTO. And at that stage, you typically start tracking it. Now, sometimes you even reach out to them before the government even examines the application, but sometimes you don't reach out to them until they would get an approval from the USPTO. Either way, if you're not able to resolve the dispute before it gets to this stage, or the government just approves the application, you're only going to have 30 days in which to file a notice of opposition. Now, you can take up to a 90-day extension at a time, but that 90-day extension has to be taken within that initial 30 days. So if you're asleep at the switch or not monitoring it, that 30 days is going to run, and you're going to be prevented from filing an opposition. So
and I think this is, and Josh, it's also a good time to mention that before the opposition period, there is no opportunity for you to directly prevent or interfere with the ability to have that looked at by a government attorney. So this is going to be the opportunity for a third party to actually weigh in on whether or not they think a trademark should register, where before then it is between the applicant and the examining attorney. And it's kind of a very one-to-one thing. The examining attorney is not influenced at all by any third parties. And then this is the chance for anyone, once the USPTO has made their decision, to oppose and say, well, no, hold on a second, we don't want this to register. And so that's why this is so important, because this is the first opportunity that a third party has to actually stop a trademark from registering.
Yep, absolutely. And typically, once you file this, if the other party wasn't really willing to engage you in negotiations, like if you had sent a demand letter and nobody responded, I have two of these right now where the other party is like, we don't think, we don't agree that there's an issue here, our client's not just going to move forward. This is the opportunity I have to force them to deal with us, right? Because if we file an opposition, their trademark won't register unless they respond to the opposition and start negotiating with us, or essentially start litigating with us. So what are the reasons you can file to oppose someone's mark? The number one and most common reason is that it's similar to a trademark that your client owns, or your client's getting opposed because it's similar to a trademark that somebody else owns. That typically is the reason that these oppositions get filed. But there's other reasons to think about filing oppositions as well. One is that a trademark might be too descriptive to be registered. And sometimes you'll see companies go to try to register marks that are descriptive in their industry to try to gain some sort of ability, maybe to use the mark on a third-party platform like Amazon, maybe just because they want to put a circled R next to it and try to stop competitors from using a somewhat common or descriptive phrase. So you may not want a competitor to register a mark that you might need to use in your marketing and advertising to describe your products and services. So sometimes you file an opposition for that reason. Same thing if the mark is generic and someone's gotten it through the PTO's review process and they're trying to register something in your industry. Another reason to think about opposing an application. Again, if the mark is a surname, is another sort of what we call descriptive mark. But if a mark is a common surname and you don't want it to register because you think it's going to affect your brand for some reason, you might be able to oppose the trademark if it's been approved on the principal register. If somebody, again, another one of these things, if a competitor is doing this, something you might be worried about. Let's say you make safety vests and a competitor is trying to protect a neon yellow color for safety vests, and they get it through the government's review process. Your client may want to oppose that because arguably if this other party gets a registration, maybe they're going to stop the ability for your client to use neon yellow for a safety vest, which we all know would be kind of a weird result. The other is something we've seen a lot recently, in the sense that we will get an application that comes in from overseas that is for a client's mark or a mark that's very similar to it, and it just claims thousands of different products or services, or hundreds or thousands, or whatever you want, just a bunch of stuff, and it overlaps with our client. But in reality, like, we might look at it and say, oh, well, all they're selling are, I don't know, towels, but they have a claim for like a whole bunch of other stuff in there, everything from furniture to rugs to baby bottles, or what. I mean, it can have these like crazy claims. Well, we can file an opposition saying we don't think there's an intent to actually use all these things. They only sell towels, and you can actually get the mark blocked for everything but towels. So you can even file the oppositions in part, essentially, by not having to go after every last claim in the application, but just the ones that might affect your client. So that's kind of common with folks from China that are kind of jamming up our register with all the kind of filings they're making that are kind of for these super broad claims. And then, one other example here would be like if a mark is famous, you'll see Nike does this a lot. Like, let's say somebody filed NYKE for a brand of faucets, kitchen faucets. Well, Nike doesn't make kitchen faucets, and it's a Y instead of an I, but Nike would still claim that's going to dilute their brand because people are going to think it might be associated with them, and it might, essentially might tarnish their reputation. No pun intended there on a faucet. So a lot of different reasons you can actually oppose a mark, right? And every client's going to have different sensitivity. If you're a Fortune 100, Fortune 500 company, you're not only going to be monitoring for your trademarks, you're going to be monitoring for people that might try to sneak something past the goalpost that you need to use in your own marketing and advertising. But the vast majority of our clients, the vast majority of small to medium-sized businesses are going to be just monitoring for the marks that they own and trying to prevent folks from registering similar marks and identifying them. So
I'm gonna hop in here real quick, Josh. Somebody
Sure.
asked a question in the chat. Somebody asked, how common is it for descriptive or generic terms to make it through an examiner and require opposition?
Yeah, I think that's a good question, Josh. I'll take this one if you don't mind. I mean, I think that it is. Luckily, the examining attorneys are highly trained and they do research to see if they have any kind of descriptive elements, but it is a spectrum. It's something that, on one end, a generic trademark is not a trademark. A generic term cannot be a trademark. And they're fairly good at noticing that but they are spending about 30 minutes or so examining a trademark application. And so things are missed. I think that it's something that it tends to be more difficult when things are right on that line of whether it is descriptive, and especially if it's a term of art within an industry. The examining attorneys are not industry focused, they are generalists, and so they might not have all the information that someone in the industry might have. And that's why it's super important to kind of be paying attention to what's being registered and what information you or your clients might have that the examining attorney possibly didn't when they were examining the trademark application.
Yeah, and I will say they've gotten a lot better in recent years. You know, in the early 2000s, 2010s, a lot more things were getting through. Now there's a heavy use of sort of Googling things and making sure they're not obviously problems in the examination process. So they've gotten a lot better about that. But we even, you know, I came across a trademark the other day and I was just shocked that it got registered. And, you know, of course, it was registered in like 2012, but this person now has this incontestable registration on something that they probably shouldn't, you know, but there's, you know, again, there's not much we could do about it now because they've had it registered for so long. But you know, it does happen that things get through. So good question. Thank you for that.
Sorry, and one more question that
yeah.
I just saw came in was about how difficult is it to demonstrate lack of an intent to use for one of these laundry list applications? And so intent to use it goes a little bit beyond the scope of what we're going to talk about today. But I believe we've done a presentation in the back about it as a filing strategy. So that also, it means that more than just you have an idea kind of out there that you might want to do something one day. It does need to be backed up with evidence that you do intend to use something. And so a lot of the times that is very broadly construed in other countries. And so what the question was if you're using a foreign application, you can apply in the US based on that foreign application and foreign registration. Just keep in mind that for every one of those goods and services that the client is applying for, they need to have an actual intent to use that they can show evidence supporting that. And it can be minor, the bar is pretty low of what that entails, but there needs to be something. So it can't just be something they may one day want to do. And so that tends to be kind of where that line is depends on which industry and kind of where the client is in certain stages. But overall, just making sure that that evidence exists and then really kind of narrowing that down. If you see one that's just for a long list of goods and services, you're thinking there may be ways to whittle that down through an opposition process.
Yeah, and to be honest, I mean, I think practically we get a lot of default judgments when we file those. Even there's, you know, we had a relatively large company that we filed one against recently, and we thought we'd get a response, and we didn't. We just got default judgment, and the PTO removed all the goods that we were concerned about. So we were like, that worked, you know, and so sometimes these companies won't even bother responding to those types of challenges because essentially they know there's not much they're going to do about it, or the U.S. is just maybe not a priority as much as, you know, the cost it would be to respond to that type of challenge at a certain point. So practically, sometimes lodging the challenge is all you need to do. There might not even be an evidentiary issue at some point. Great question. So talked a little bit about oppositions. We're going to come back and tie this all together, but I wanted to talk and just kind of give you the full picture, which is the other type of procedure that you can actually file with the United States Patent and Trademark Office is Trademark Trial and Appeal Board. It's a mouthful.
Hey, Josh.
Yes.
Sorry, there was a couple other questions that came through. I was trying to grab you before you got too far in there.
Sure.
We have one. How can I make sure a logo I want to use for my law firm isn't already taken and won't have issues in the future?
Sure, that's a good question, and I mean, I'm happy to even talk offline about that one. But basically, we'd want to do a trademark search, and we've got other materials on that one it's a good topic that we can get to. But I wanted to make sure enough time today. Feel free to whoever asked that question to email me, and I'm happy to give you some more thoughts on that too. But essentially, just running a trademark search.
We have a couple other ones as well. Mm-hmm. You mentioned software that monitors applications for potentially confusing marks. Can you give examples of this software?
Yeah, sure. I mean, everybody from CoreSearch, the more traditional people like CoreSearch and Clarivate offer this service. Some of the more non-traditional, what I call non-traditional ones, sort of the upstart companies, One we like is called TMTKO. We think they do a pretty good job, and their software is pretty interesting. And so, yeah, there's a lot of options out there on the market now too. And then, it's like anything else. If you're going to use a software and that's the only thing you're going to use, you're going to miss things. So we typically do, hand searches as well, meaning like a little bit more than just relying on the software to pull things, but running searches ourselves periodically for clients that are engaged for monitoring services. But if the softwares do a pretty good job picking up like the major issues.
And one more quick survey. Does anyone think that Texas tamales is equivalent to Philly cheesesteak, New York pizza, or New England clam chowder?
Oh, I don't touch Texas politics. So
Yeah, and I think that's actually a good example of kind of what we're about to talk about with cancellations, because the meaning of words change over time, especially when it comes to trademarks. And there was a recent, very, very visible time when this happened for Taco Tuesday. And that was a registered trademark, and it recently was the subject of a cancellation proceeding by Taco Bell, I believe. Forget exactly what happened there, but yeah, and ultimately the claim was that over time, people don't associate the word Taco Tuesday with any one company. And so it now fails to function as a trademark. And so that is actually a claim that you can make for cancellation. And I think that's probably a good segue into the cancellation part, that if you or your client believes that a phrase is registered that shouldn't be, you do have the ability to challenge that. And the way you do that is through a cancellation proceeding.
Yeah. Excellent segue there. Thank you for laying that up for me. So a cancellation proceeding is the same type of proceeding as an opposition. So everything looks the same, except for it basically has a different label and comes at a different time. As a reminder, an opposition is filed while a trademark is in the application process. Once a trademark is actually registered, you can file what's called a petition to cancel that mark on a lot of the same grounds that you could have used in the opposition process. One of the great things about trademark law is it tends to be pretty forgiving. And so if a client missed something in the opposition, they can always come back and file a petition to cancel after the mark is registered. This, kind of common reminders on this slide. Again, we're not talking about awarding damages or attorney's fees at this point, or any kind of conversation about whether the mark can be used, solely about whether that existing registration can remain on the U.S. register. And so that is essentially the question that you have to answer. One of the critical elements to think about here, just from like a timing perspective, is that you lose the right to challenge a trademark on most grounds, but not all, after 5 years of registration. So once a mark has been registered for 5 years, it's very, very difficult to start challenging it for all the things you might be able to challenge it for within that first 5-year period. One of the big exceptions would be what Eric just said, which is, if a trademark becomes generic, then you can certainly challenge it.
Yeah, and I think kind of to piggyback on that, that is something also on the other end that I answer to clients a lot. They, once a trademark is registered, can someone still cancel your trademark? And the answer is yes, they can, for up to 5 years, which could be an eternity for a lot of kind of young businesses. And so I think that's something just to keep in mind, that registration is not the end of the process when it comes to trademark protection. It is an ongoing thing, and something that may have been a problem not a problem in year 1 or 2. Year 3 is when they may have gotten to the point where they're on the radar of a company that they're now being confused with. And so I think it's good policy to give some time, but the longer you wait to bring claims, the harder it becomes. So it kind of goes both ways. That's why it's really good to both be vigilant on the enforcement side, and then also just aware of your competition when it comes to once you have a registered trademark on the other side.
Yeah, absolutely.
Sorry, I'm just going to jump in here real quick too. I got a couple more questions in here. Somebody asked, is that true even if you don't file a declaration of incontestability?
It is, yes. So incontestability is a somewhat mysterious and mystical thing that helps with in federal court to show that you are the owner of a trademark. 5 years is 5 years. So regardless if you file for incontestability, after 5 years, that is when it triggers the 5 years from registration. After that, you cannot utilize many of the things that you could before 5 years. So those disappear regardless of if you file for incontestability or not.
All right, and then there's another question in here. Somebody asked, what happens if someone trademarks the same name as your law firm? Can you oppose a trademark from another state that has the same name when no attorney exists by that name in that state?
Yeah, I mean, it's a good question. In most cases, if, it comes down to the whole question of interstate commerce and what is interstate commerce these days. For example, I mean, I'll use ourselves as an example here. We have a federally registered mark on Gerben. There was a personal injury firm in Arizona that filed a trademark for Gerber, which is the one letter difference in the name that I always get confused for. Everybody always says, oh, it's like the baby food. And I'm like, no, I missed the jackpot by a letter. But, so here was a Gerber personal injury lawyer, and we're Gerben and we do trademarks. And one of the things you learn when you do trademarks is that personal injury lawyers like to dabble in trademark matters, even though they have no idea what they're doing. No offense to anybody out there that might have done that. So what we found is, so we're worried because personal injury lawyers genuinely do take on these kind of cases sometimes. And so we actually did negotiate with this person, and you could see it on the Federal Register where they're not going to offer trademark related services. But, I'm a measured person. I'm a realist. Like, this guy's in Arizona as a personal injury lawyer. Like, as long as he's not offering trademark services, like, we're not going to overlap in the marketplace. But yes, I mean, to answer your question, so every case is going to be a little different, and it depends on how identical it is, how unique your surname is, how much marketing you do outside the state in which you're operating. Like, for us, we operate we have clients from all over because we're in federal practice. Now, local law firm, might not operate. If you're in Pennsylvania and someone's out in Oregon, well, what are the chances there's going to be actual confusion there? So, you have to kind of measure and look at the particulars of the case, but it's certainly something that can come up in the context of an opposition or cancellation if you're having trouble registering the mark, which as a good segue into this slide, which is that when do you sometimes use cancellation proceedings? And this is one of the most common places we use it, where let's say you have a business that's been operating for years and years and years, but for some reason never filed a trademark application. And this happens a lot more than you think it would. And then they go to file it, but find out that some other business just filed the same trademark 3 years ago and actually has a registration. Well, because we're within that 5-year window, we can file a petition to cancel that trademark registration, knowing that it's likely to block our client's application we're trying to file. And the claim would be that we use trademark first throughout the United States, and we're the rightful owners of the registration. I was having a conversation the other day with a client because we filed a trademark application. We are 99% sure it's going to get denied because of something somebody else filed, and we have been using it much longer. This other trademark registration that's sitting there is going to hit the 5-year mark in a couple of months. So they have to decide if they're going to file this petition to cancel or not, because if they don't file it, they're going to lose the right to challenge that registration. And it's very likely that registration will just block them forever then from being able to get a registered mark. So this is one of the examples of how you would use this. If you do a trademark search, you find a problem and you're trying to counsel a client around, what you're seeing on the register, especially if the client's been using the trademark for a while. So the next sort of question is, well, how do you get these processes underway? How do you start a cancellation opposition? The initial document or pleading that you would file with the Trademark Trial Appeal Board looks like a federal complaint. It's not as typically, there's not as many rules. The pleadings are typically a little bit more simple. So they might be a lot shorter than you might see in a federal court. But generally speaking, they look a lot like a federal complaint would. And that would be the same for whether it's a notice of opposition or petition to cancel. It's essentially the same thing with just a different opening paragraph and closing paragraph. The interesting thing is the USPTO did just raise their filing fees to file these proceedings, they're now $600 per class that you want to cancel or oppose. So let's say a mark that you're opposing or canceling in 4 different classes of goods and services, your filing fees can be $2,400. And that's not insignificant especially for smaller entities that are out there. And it's a part of the consideration, quite frankly, a lot of times from our clients, because we'll say, hey, for us to draft and file this, of course, there's going to be more fees, when an answer gets filed, but just to draft and file it, let's say it costs about $1,500 to $2,000 in legal fees. It might be more in filing fees than the legal fees to get the thing prepared, to get the thing filed, just because of, how many classes it might be. So, but that's how you would start. It's just with that pleading, and then it gets filed There's no, you don't have to actually serve it like if you would in a federal court. So the trademark office will actually take care of service for you, which is really nice and keeps things simple.
And to that point, Judge, so USPTO filing fees are per class that you are either opposing or canceling. Typically, it is somewhat rare to do a partial cancellation, but it is possible you might want to only cancel in one class. But you can choose to only target specific classes, and it's $600 per class.
Yep.
I'm going to jump in here again. We have a couple more questions. Somebody asked, do the fees increase based on the number of applicants?
Well, it's $600 a class per trademark you're opposing or canceling. So if it's like a joint applicant application that you're opposing or canceling, then no, it wouldn't change the fee. But if it's multiple, sometimes you're filing an opposition or cancellation against multiple trademarks owned by a party or parties, then you'd be paying the per class per trademark fee.
Alrighty, and then the next question, somebody asked, what if the other trademark registration is opposing your prior mark because they are claiming that the mark is in a crowded field, citing the juice generation case?
Yeah, so that would be really down to the idea of failure to function. So if something is so ubiquitous that it doesn't function as a trademark, but that kind of crowded field argument, that's usually an argument that's made in that before time, when you're actually dealing with the examining attorney. So if you're making the argument that my trademark should be able to coexist with all these other similar trademarks, that's a good argument to use with the examining attorney, but that's not a grounds for opposition unless it is so ubiquitous that no one should own that phrase. And that's when it gets into something you can actually challenge. And so that would not be by itself a grounds for opposition, but that would be a defense if someone filed an opposition against you saying, and then you could say, well, part of the reasons that I'm going to try to fight this is that look at all these other people using similar trademarks. That's a good line of defense against an opposition, but that's not a grounds for bringing one. I hope that answered the question.
All right, last question then here for this section. Somebody asked, if a company has not filed for a trademark name but wants to oppose an infringing application, should they wait for the opposition to be completed prior to submitting their own application?
No, you should submit your own
No.
application. Yeah. So
File early.
Yeah. Visceral reaction from Eric and myself in the sense that, you have to, the filing date of a trademark application is the federal priority date. So essentially what could happen there is if you don't file an application, a third party files. So you win, let's say you win the opposition, now you got another problem to deal with. Get your application in, get it moving. Absolutely. As soon as possible at that stage. Good question, but a very clear answer on that one for sure. So,
sorry, quick question that I just saw come in through the chat was who is standing to file cancellation on the grounds that the marks become generic? That's actually an interesting question. So standing, it's also called a statutory grounds for cancellation because standing technically means something in court, not the TTAB, but standing regardless is this very low bar that says you have to have some kind of skin in the game. And typically a mark that has become generic, it is being openly, that is a question that is trying to be decided. There was one recently about Rapunzel that one of our colleagues took on that on behalf of a law clinic, and they said that the law clinic, just as a member of the public, potentially has standing to bring this, whether they could actually prove that they had anything, that's kind of another thing. So it's a very, very low bar, especially when it comes to genericism, that because a generic trademark, the public policy behind that is that that the public should not be monopolized. Essentially, a word that's in the public kind of domain should not be monopolized. And those are all kind of words that are not, they have some loaded words to them, but I think that's the kind of thing is that if you're thinking about canceling a trademark on genericism because you're a member of the public, that's possible, but usually it's going to be in the context of a client that's going to be harmed because of that registration.
Yeah. So
Before you keep going, Josh, sorry, there's just a couple of questions that keep floating around about CLE codes. We will have a passcode for the CLE. We're going to give that out at the end of the presentation when we give you a link to the attendance form, and you can put it on there then. There will only be one. Thank you.
thanks, Lacey. So, one of the questions we commonly get from clients is, okay, well, obviously, what's it going to cost and how long is it going to take, right? And the answer is that the vast majority of an opposition and cancellation proceedings are going to settle early on. This is anecdotal because I don't have our exact numbers, but I think Eric would agree. I would say, I don't know, 90% of the cases, if not more, settle before we get to any kind of real discovery, just because the parties don't want to pay. Again, there's no awarding of attorney's fees here, so everybody's paying out of pocket for whatever their lawyer's charging them, and most people don't want to pay lawyers to do discovery and depositions and all the things that it would take at this level. You can always remove one of these cases to federal court, and so that's something that if there's an infringement claim, so there is the ability to get out of this tribunal, if you will, if there's higher stakes. So most of the time, the case is going to resolve before it goes through discovery and a trial. But if the case were to proceed and you don't settle it or it doesn't get removed to federal court, essentially the first thing that happens is the answer deadline is always 40 days after the opposition or cancellation is filed. So you have that 40-day window to file your answer. If the parties want to delay that, they can. All you have to do is get consent from each counsel, and you can file for an extension or suspension of the case for up to 90 days at a time. So a lot of times what you'll do is you'll file this, you'll get in touch with opposing counsel or vice versa. We had a case where a client had one filed against them. We got in touch with opposing counsel, said, look, we're interested in settling. Here's an idea of how we might settle it. Opposing counsel said, yeah, that's close, not it, but close. So let's suspend the case. Let's not worry about filing an answer, going through all those motions. It's going to cost both clients time and money. Let's just try to work this out. So that's one nice thing about this, is it's not like federal court where they're going to be sort of breathing down your neck sometimes to get the case moving or dismissed. The idea here is they will let this go. And I mean, some cases get suspended for 6 months. I think we have a case right now. It's been in suspension one way or another for the better part of a year. So you can really kick the proverbial can down the road a little bit on these if you want. But typically, if it goes all the way through the case calendar, which I'll show here in a minute, it can take up to a year and a half or more to actually get to a decision. As we mentioned, similar to a court case, when you get into discovery, you're going to do requests for documents, admissions, interrogatories, and you can take discovery depositions as well. And those noticing depositions is typically one way to start a jumpstart settlement discussions if the other side is kind of been dragging its feet. We've done that a few times, and all of a sudden everybody wants to really make progress on settlement, which is great. But they don't want to get deposed, or their client doesn't want to get deposed. So this is
something real quick there is that this is it uses the federal rules of evidence. So if anyone on the call is a litigator, that it will look very similar, but it is, I've been told by many federal court litigators that the TTAB has these rules that just are baffling and catastrophic when they're missed. And so there's a number of rules, like one that you need to serve all discovery with at least 30 days to respond before the close of discovery. Otherwise, you cannot serve it. And we've had situations where that has been very detrimental to clients who wait till the last minute and then a day afterwards file, and they say, well, no, that you missed that deadline. And so I think there's a lot of rules within the TTAB with how they count interrogatories and admissions and requests for production. And so keep that in mind, that if you're kind of getting into this, it looks very familiar if you do a lot of federal litigation, but there are some rules to be very aware of.
I'm going to hop in here real quick with another question from the chat. Somebody asked, do you have opinions on the #law trademark registration from Morgan & Morgan? They just settled with the PTO agreeing to register.
So I think that I haven't looked at the record here. So hashtags, this is kind of off topic, but I think that they can, by themselves, they are not trademarks. They're considered the same way that a domain name is, or a hyperlink is. It is a thing that points you in a certain direction where you can get things. It's a mechanical thing. It is not a trademark, and that is pretty settled law, but it can become one. if it's used in a prominent way where consumers, when they look at it, only think of one company, they don't have to think of Morgan & Morgan, but they have to see hashtag law in the header of a website and think that that belongs to one entity. And I'll keep my opinions to myself personally, but that is, I think, would make for a difficult thing for anyone to argue that that would be tied to a single entity. But it all depends on what the facts are. And I think the record would have to show that consumers would think that. And yeah, that will be an interesting thing to keep a look at. The one thing that is for sure is that it would be difficult, if not impossible, for anyone to stop someone from using hashtag law on social media or as a normal hashtag. And so I think that's what people kind of look at that and they say, oh no, are they going to come after if you register the word "the," can you stop people from using the word "the"? The answer is no. You have to use it as a trademark in a way that's confusing. And so I think that's kind of my short spiel on that. So hopefully that isn't too off topic.
Yeah. No, and I mean, just to put I think there's a lot of time and money that's wasted on stuff like that. I mean, I don't see why. I'll be less, down the middle than Eric, but I would love for them to try to enforce that trademark against one of our clients. Let's put it that way. We would have a field day. I don't think that that's a legitimate. I mean, that's I don't see where they're going with that. But nevertheless, these are the things that people sometimes spend time litigating. Back to our trial calendar. As you can see here, this is something that I try to show our clients so they can get an idea of what they're getting themselves into. Let's say a notice of opposition was filed just on Monday, on the 18th of September. The answer deadline is going to be October 28th. But as you'll see here, the reply brief and the oral hearing will not happen until March of 2025, not even March next year, but March the following year. So these things go on forever. I almost believe that they're meant that they do this so that you'll settle at some point because everybody will lose interest. But they really just take enormous amount of time to kind of get to a place where you can actually get a resolution. So and again, I think there's a practicality to when you file these things. The vast majority of them will go into default one way or another because one party doesn't want to defend it or pay to defend it, or there will be a way to settle the case because both parties want to get it off their docket and this is the cancellation. So it's the same thing. You can see it's the same exact trial calendar, takes just as long to get through either a petition to cancel or a notice of opposition. As we get to the end of this, just two kind of final things to go over. One, if you are filing an answer, just a couple of things to think about. One, you're going to have, much like federal court, you're filing, admit, deny type of answers, for each paragraph that's in the petition to cancel or notice of opposition. Biggest secret weapon, look for counterclaims. Many times they're compulsory, so if you don't make them, you lose the opportunity to do them. And a well-pled counterclaim can actually surprise the plaintiff in the case, whether it's the opposer or the petitioner, but technically the plaintiff, because they're not really thinking that someone's going to come after their mark. One of the things we've done in the past is somebody files an opposition. Our answer is a counterclaim for cancellation against their mark because we think their mark is, descriptive or one of those other reasons. So this is, all those reasons we went over earlier in the slide. Those could be counterclaims that you're now using when somebody's being aggressive against one of your clients. And again, I find it to be a highly good technique for driving good settlement discussions when all of a sudden you're not just on the defense, but you're playing offense too. And now they got to play defense and the case is just kind of blown up in their lap a little bit. So I think that's that's sort of the secret sauce here, is making sure you don't forget to file compulsory counterclaims if you're filing an answer in one of these proceedings. And this is the final slide when it comes to the Trademark Trial and Appeal Board and the opposition cancellation proceedings, which is that, how do we resolve these things? Well, most of the time we're going to, as we talked about sort of around the edges here, we're going to look for settlement opportunities. The easiest ways to settle these cases are typically as follows, although every case is different. Can we limit the goods or services that one party's claiming, right? So sometimes you're making a very broad claim. Sometimes you want to narrow those claims down. And if you narrow them down sufficiently, your client may be okay with that. And so that's one way to kind of consider looking for ways you could settle. in a settlement agreement, while these cases are not about how a trademark is being used, many times the agreement itself will address use of the trademark. We've had a case recently where the idea is that our trademark is a two-word phrase, and the opposer wants to ensure that both words are always used in the same font and size and style, and that you're not emphasizing the first word over the second word of the mark. So there can be different things like that that come up in settlement negotiations about how a mark is going to be used in the marketplace to limit the potential for confusion. And as we talked about earlier, one of the reasons we file a lot of oppositions or cancellation actions is just to clear the road for our own clients' trademark to register. Our client may actually say, we don't care about this other trademark, like they can have their mark, I don't care about it, but that mark's going to block their registration. So if the other side would consent to our mark being registered, meaning in writing, actually say, yeah, we're okay with this, and the government approves that consent, that can resolve the issue. So sometimes providing that consent to a party on the other side or getting it for yourself, that's enough to resolve it, or one of the reasons to resolve it. One of the things that's unique, I think that more unique about our practice when we're doing settlement agreements, and something we always try to include in our agreements, is we have to protect against an unpredictable USPTO. One of the most infuriating things, and apologies for anybody from the PTO on this call, but one of the most infuriating things about the agency is the inconsistency. So what I mean by this is that our client files a trademark in 2015 and gets a registration. In 2017, another trademark's filed and gets approved, despite the fact our client's mark is there. And then in 2022, we come back and file a new application for our client's mark for a logo, or maybe we add a few things to the goods and services or whatever it is. And then the PTO denies our new mark by citing that mark that was filed in 2017 after our previous one was filed. And we'll say, wow, you already let this other one in, even though we had a registration. Now you're telling us we can't expand anything, or we can't do anything. We can't even get a logo registered. And they'll say, no, it was a mistake back then. We're not going to continue the mistake. And that's what you'll hear a lot. It's like, so one of the ways to protect against this is in an agreement you're going to sign, if you're going to let a trademark register as part of a settlement agreement, is say, look, we'll let your mark register. The condition is you have to promise to consent to any future applications we file for our own mark, so that if we run into a problem with the PTO down the stream, we have this agreement we can come back to, you'll sign the consent, it'll be no muss, no fuss, and we'll all be able to move on. So that's just something to really think about down the road for your client. Don't just think about the matter in front of you. Think about, if I have to register more marks for this client later on, is this going to become a problem again? And have I just signed away my rights to do anything with it? And that's, to me, one of the biggest hidden dangers in signing settlement agreements. If you are to litigate these things, as we mentioned, discovery, depositions, trial period, if you get all the way to the end and you're litigating it, you're easily going to be around $100,000 in total cost. In some firms, you'll be a lot more than that. Sometimes maybe it'll be a little less if there wasn't as much discovery and depositions. Most of these costs can be incurred in stages, though, for clients, so it's not like they're paying it all at once. And as you saw, the case calendar can be almost 1.5 to 2 years. So maybe sometimes clients can, the bill is not coming all at once. It's a little easier for them. But just to get an idea of like, hey, this is going to cost a lot of money if it goes a distance, is an important thing to impress on clients.
Yeah, and Josh, we got a few good questions before we go into our very quick final
I was gonna
topic.
say, yeah, we're
running out of time,
actually.
we going back to the beginning with notice of extensions for oppositions. I actually wrote an article about this a few years ago that my number one advice to clients is do not panic, because there's a lot of reasons why people file extensions. It might be that a law firm is monitoring and they haven't even talked to the client yet. They just want to make sure they've got time to ask the client, hey, is this a problem? And so getting a notice of opposition does not mean that they are imminently about to file an opposition or a lawsuit or something like that. I wait to see if they reach out. I do not, unless it's a very specific thing where I know the other party or I might know the attorney who filed it. I typically do not reach out if the only thing that has been filed is a notice of extension for an opposition, unless there's a very good reason to. But because most of the time that could just be testing the waters, kind of keeping things going, and you could force their hand to do something by reaching out and potentially escalating something that they may have just let go because it's not worth the time or the money. The next question, Josh, do you have anything to add to that?
No, I think that's great. Yeah.
Yes. The next thing is that counterclaims are not available against pending applications. It's absolutely right. If an opposer has a pending application, that is irrelevant to anything that is going on before the TTAB. The only thing it maybe would give them is standing. If they don't have a registered trademark, then the only thing that matters is their common law unregistered rights that they can prove. A pending application is not going to be considered to give them any kind of rights in those circumstances. So, as far as leveraging favorable decisions, I think it's kind of helpful to use the reasoning that a board or that the examiner might have said why it was denied. But ultimately, that's not going to be, that won't be considered by the board as anything that would give them any kind of leverage, or vice versa.
Erica, I think we're just going to take these questions and we'll get to expungement and everything else the next time, because we got enough
Okay, well,
questions
I
here to
can
kind
actually, so let me give
Yeah.
our final section is on expungement and expungement and reexamination. And the reason why I am so gung-ho to talk about this is because I had the pleasure of filing the first one ever. So if anyone is ever wondering what trademark nerds brag about, that is one of them. And so essentially what this is that in 2019, a new law passed called the Trademark Modernization Act. And that allowed two new proceedings, expungement and reexamination. And essentially what this is a different way of challenging a registration that was not previously available. If you think of oppositions and cancellations as kind of like your Phillips head screwdriver and your flathead screwdriver, think of expungement and reexamination as that one weird tip that only works in that one situation, but when you can use it in that one situation, it is unbelievably valuable and time saving because it is extremely narrow. This is for situations in general, and we'll kind of get, if you want more specifics, we'll either do another presentation or you can email Josh and I, but the idea is there are certain registrations that have things in them that have never been used in commerce. And if you can show that, if you can show through an investigation that when this application was filed, that 15 of the 20 things that were in this application never were sold in the marketplace, and then you can ask the USPTO, hey, can you look at this? Can you make them show that they were selling it at this time? And that is different from a cancellation and an opposition, because a cancellation opposition, you're involved in it. You or your client are actively going toe to toe with this other side. These allow you to actually say, Patent and Trademark Office, you deal with it, and you provide them all the stuff that you have. You no longer have to kind of be directly involved. So if there is a situation in which you look at something, one of these laundry lists, and say, well, either this is a fraudulent specimen. We see that a lot with some of the Chinese applications that have been filed in the last 10 years. It looks like they just photoshopped on a name onto a stock image. That it never should have registered in the first place. Then you may have a different way of approaching it that would not expose the client in the same way that an opposition would. And so there's pros and cons to that. I'll kind of have that be the little taste of what potentially there is another way, but we won't go into too much detail. Feel free to take a look at the slides. I think they do a good job, and then reach out to us with any additional questions about how you might incorporate expungements and reexamination into the process to help potentially either save money or save some exposure, because there's definitely pros and cons to the different ways of doing it.
That was a very good, quick overview, Eric. Thank you. And I'm sorry that, we clearly did not time this out extraordinarily well before. Normally, we always go faster than we anticipate.
Well, we got some great questions too, and I think that's probably a great way to end too. And if any questions we don't either get to in the next 5 minutes, or if you think of any afterwards, then Josh and I are happy to answer any questions either through email or through a phone call. Just let us know.
Yeah.
Yeah, and I have a few more questions here if we want to jump into it.
Sure.
So one of those is about, this is all fine and great until you get someone on the other side that has such deep pockets, or what we will affectionately refer to as trademark well, not affectionately, we will call trademark bullies, but also highly litigious individuals like Monster Energy, or some of these ones that we see a lot of frequent oppositions. How do you deal with someone like that? And I think that there is a number of strategies that can be used. A lot of the times their strategy is simply having default judgments. And for all of the, and I see this a lot, that people say, well, we have won so many cases, and then you look and it's like, oh, 99% of them, no one responded at all. And so part of it is once you respond, once you start making them spend time and money on it, it does get expensive for both sides. And usually if you are applying the right pressure, there can be something that's worked out. They're not usually in the business of saying hard line, we're not allowing anything with Monster, because they end up entering into a lot of different kinds of agreements that are will help that kind of. There are ways to resolve these and still potentially get a registration with some back and forth. And it is just a matter of kind of, most of the time that is outside of a lot of small trademark applicants' ability to respond. And so having some of these techniques that are available, I think, is helpful. But unfortunately, those kind of things exist, and you just have to kind of do what you can to deal with them. Survey experts, I think this is a great thing survey experts are extremely helpful in kind of what I call late stage litigation, that if this is going to go to the board and it is extremely important to both sides, then survey experts, that can be extremely useful information. The average survey, I think, costs between $30,000 and $50,000 to do. And so we don't see a lot of surveys because of that exact reason, but they exist, and we're defending most of the time. If you're going to spend that money, why not just do it in federal court? But I think that there are still a lot of survey experts that are used in opposition proceedings. Final question, I believe, and with some good timing, is how do you trademark a law firm name given that it's primarily a surname? So a surname, as kind of suggested by the questioner, is that a surname cannot generally be a trademark to begin with. So my last name, Perrott, is something that I'd have to show that when people see that last name in the context of the services that I provide, they only think of one person. There's only one Perrott, and I think there's only one Perrott trademark attorney that I know of. There's also a race car driver that's called Eric Perrott that I constantly get news updates for. But a good example is Gerben. So Gerben is our firm's name. It is the kind of thing that we go by, and it is a registered trademark. And so you're able to, over time or over showing that kind of recognition through evidence, you can make something that's primarily merely a surname into a registered trademark. And so that goes for descriptive phrases as well, if you can show that kind of evidence of consumer recognition.
That's great. And thank you again for everybody being here today. Just a final few reminders. Passcode for today's, if you need it, is World Series. Please stay in touch with me and Eric. You can follow us on Twitter or LinkedIn. If you have specific questions, you can always email us. One of the things we always say is that if you run into a trademark question, even for a client that you don't feel comfortable handling, we work with other lawyers and law firms all the time to kind of provide that outside specialty, and so you don't have to. You can continue to manage the client, and we can hopefully help out. But obviously, any other questions or anything that comes up, you have our contact information. We're always happy to talk. And thank you again for being here.